Yo, what's up? Welcome to Biology 101. I'm going to be reading from the book out loud with techno in the background. Trying to make this channel. This is my first video. It's probably not going to be very good, but here you go. Actually, we do law first. It's hot as balls in here. Hot as goddamn balls. Okay, Chapter 24, Construction Contracts. The engineer is not normally a party to a construction contract. The engineer usually has a separate contract with the owner, the client. Under the separate contract, the engineer may undertake to prepare plans and specifications, to assist in the tendering process, and to administer the construction contract between the owner and the contractor. As administrator, the engineer may make decisions of major significance to the rights and obligations of the owner and the contractor. For example, many construction contracts provide that the engineer shall, in the first instance, interpret the provisions of the contract and be the judge of the performance of the respective obligations of the parties to the construction contract. The words "in the first instance" are included for the purpose of reaching timely decisions during construction, yet leaving to a more appropriate form, for example, a court or arbitrator, the ultimate decision as to how the contract ought to be interpreted. Some examples of aspects of the administration of construction contracts with respect to which the engineer is often authorized by both the owner and the contractor to make decisions are as follows. 1. In the preparation of payment certificates. 2. In the preparation of certificates to evidence substantial and final completion of the work. 3. In the event of delays during construction, the engineer may determine the appropriateness of extending time for completion. 4. In the determination of whether the contractor has failed to fulfill his or her obligations to an extent that would justify termination of the construction contract. 5. In the valuation of changes or extras to the contract, the engineer may decide appropriate changes in contract price and in time for completion. 6. In determining whether actual subsurface conditions differ materially from those conditions described in the plans or specifications for the work. 7. In the events of emergencies, the engineer is usually authorized to direct the contractor's work methods to ensure safety in property and workers. And 8. To inspect the progress of the construction and to reject work that does not comply with the contract documents. The manner in which an engineer ought to discharge decision-making powers has been the subject of court decisions. In 1953, the Ontario Court of Appeal decided Brennan Paving Co. Limited v. Oshawa. The court considered the conduct of an engineer who acts as agent for the owner and who also acts as certifier of payment certificates. The court concluded that as a certifier, the engineer is required to act judicially and in an independent and unbiased manner. The engineer should not then act as agent on behalf of the engineer's principal, the court stated in part. Whereas here the engineer's certificate is a condition precedent to payment, the engineer occupies two positions. First, one as agent of the owner under the contract. Second, a quasi-judicial position as certifier between the parties. Hudson on Building Contracts, 7th edition, page 286. The two positions are distinct and separate. Different duties attached to them and different consequences flow from the performance or breach of those duties. Under the law of principal and agent, he may, within the scope of his duties, bind his principal. As certifier, deciding between the parties, he must act judicially. To act judicially as certifier requires him, where the question arises, to consider and give effect to any conduct on his part as agent vis-a-vis the contractor which has bound the owner as his principal to the advantage of the contractor. In this connection, he must act qua certifier as independently as if some other person rather than himself had been the agent of the owner under the contract. All that seems crystal clear to me. In 1960, the Supreme Court of Canada decided Cam Lee Construction Limited versus the town of Oakville. The against the entire town. The construction contract provided that the decision of the engineer shall be final and binding upon both the contracting parties as to the interpretation of the specifications and as to the material and workmanship. The contractor disagreed with the decisions of the engineer. A battle of wills developed between the engineer's representatives and the contractor's representatives. The factions disagreed on many basic questions concerning method and detail. The Supreme Court of Canada held that the contractor was not entitled to repudiate the contract on the basis of the engineer's conduct. Under such a contract, the court held an engineer is required to act judicially. The engineer must make decisions dictated by the engineer's own best judgment. He or she must decide the most efficient and effective way to carry out the contract. The engineer's judgment must not be affected by the fact that he or she is being paid by the owner. The question of the manner in which the engineer carries out duties was also considered in another case. The 1959 decision in Croft Construction Co. versus Terminal Construction Company. Contracting parties. Wait, where'd the techno go? Turn the techno back on. The psychedelic, the psytrance. Turn the psytrance back on, not the techno. The psytrance. The question of the manner in which the engineer carries out duties was also considered in another case, the 1959 decision in Croft Construction Co. versus Terminal Construction Company. Contracting parties had agreed that payment to the contractor would be based on calculations by the engineer. The court upheld that the engineer's figures would govern the payments, even if the engineer had made an honest mistake. The Ontario Court of Appeal stated in part, "It is well considered that a computation of the character in question is conclusive and binding upon the parties in the absence of fraud or bad faith, or unless the person entrusted with the duty of making it has knowingly and willfully disregarded his duty. It is not suggested here that there was any fraud or bad faith on the part of the engineer. The immunity of a certifier from any loss caused by lack of skill has come into question. In 1974, the House of Lords decided Sutcliffe versus Thakral et al. An architect who acted as the owner's agent in preparing payment certificates was, the House of Lords held, under a duty to the owner to exercise care. The architect was, in fact, liable to the owner for negligent over-certification, unless he could show that he was acting as an arbitrator in preparing the certificates. The architect was unable to substantiate that he was acting as an arbitrator, thus he was liable for any loss caused by his negligence or lack of skill. The House of Lords concluded that immunity would be extended only to the arbitrator. In his capacity as certifier on behalf of the owner, immunity was not available to the architect. To summarize, where an engineer is empowered to make decisions that are final and binding upon the parties to a construction contract, the engineer must act judicially, notwithstanding that he or she was originally retained by the owner. In acting judicially, the engineer must act independently of the owner, his or her principle, and in good faith. Provided this is the case, the engineer's decisions will be binding upon the parties. In addition, an engineer may be liable for loss caused by negligent certification if future Canadian court decisions apply. Sutcliffe vs. Thakral. Certificates fraudulently prepared. Canadian courts have heard cases that involve fraudulently prepared engineer certificates. In Grant, Smith & Co. vs. the King, certificates prepared by an engineer in collusion with a drilling contractor represented a fraudulent attempt to overstate rock quantities. The certificates were set aside by the court. Inspection services. In administering a construction contract, an engineer normally acts as an inspector. In doing so, the engineer must discharge all duties completely and must demonstrate a reasonable degree of care and skill. Unless the contract provides otherwise, the engineer will be expected to inspect all significant aspects of construction. The inspection may be done personally by the engineer or by competent representatives selected by the engineer. The courts expect a high standard for professionals. The standard is illustrated in a 1976 decision of the Ontario Court of Appeal in Dabu versus Zuliani et al. An architect entered into a contract for the design and supervision of the construction of a house. During the construction, a metal chimney was installed too close to wooden joists. The oversight eventually resulted in fire damage to the house. The court considered the architect's inspection of the chimney installation and stated, prior to the installation of this prefabricated chimney which caused the fire, builder had installed another prefabricated chimney in this house which serviced the furnace in the basement. This chimney was installed in direct contact with the wooden joist at the first floor level, and was observed by the architect, who cautioned the builder against this practice and directed correction. The prefabricated fireplace was late in arriving because of some urgency in completing the building. The fireplace, together with this chimney, was installed on a weekend in the area where the prefabricated chimney passed through the second floor level, was boxed in and covered with the gyprock. As a result, the offending installation was not observed by the architect. It should perhaps be added that the architect took no steps to have some of the gyprock removed, so that he might examine the chimney installation, although that would have involved trifling cost. The proper installation of this type of chimney was critical to the safety of the dwelling. The fact of a previous similar improper installation and its correction should have magnified the concern of the architect rather than diminished it, as was argued on their behalf. The failure of the defendant architects to ensure that the chimney leading from the fireplace was properly installed, even if this required the removal of some of the concealing gyprock, was a failure to meet the reasonable standard of care which they owed to the plaintiff, and the appeal of the architects against their liability was therefore dismissed. The decision may seem harsh to some, however, it illustrates the very high degree of care expected by the courts. The engineer's advice to the contractor. In a construction contract, the engineer is normally expected to inspect rather than actually supervise the work methods of the contractor. Most construction contracts provide that the contractors shall have complete control of construction methods and procedures. However, consistent with tort law principles, the engineer may be expected to advise a contractor in circumstances where the contractor is reasonably relying on the engineer's expertise. This may well require the engineer to make a difficult judgment call, and the engineer must be extremely careful in doing so, as unwarranted interference with the contractor's work methods may give rise to a damage claim. Some contracts provide that the engineer is to approve the contractor's work methods, in which case the engineer's obligations are more clear. To illustrate, in 1977, the Supreme Court of Canada decided Demers et al. Versus Dufresne Engineering et al. During the construction of bridge piers, the contractor failed to use sufficient vertical reinforcing steel in constructing a caisson. The caisson exploded under pressure and had to be rebuilt at a cost of $1.4 million. The Supreme Court of Canada held the engineer 50% liable for the damage. In part, the court stated the explosion of the caisson was due to a glaring error in the method of performing the work that was selected by the contractor. Having failed to take the low resistance of concrete and tension into account, the latter did not provide for the use of vertical reinforcing steel. The engineer was aware of the incorrect method of doing the work. If he had not been aware of it, I would have had no hesitation in saying that he ought to have been, since this was such an enormous error. By remaining silent, the engineer implicitly approved the work method chosen by the contractor. Moreover, he also implicitly approved the minor alteration, which consisted in adding a small quantity of vertical reinforcing steel, and which, even having regard to the preliminary calculations made by this representative, was obviously inadequate. By committing these two errors, the engineer effectively allowed the work to be performed incorrectly, and this caused the accident. The contractor's error indicates how much he was in need of the engineer's guidance in order to perform the work properly. This need for guidance gave rise to the engineer's obligation to give it to the contractor to see, in short, that the error be corrected. By failing to carry out this contractual obligation, the engineer became liable toward the contractor. Contract administration. I'm going to grab my coffee. Be right back, everyone. Be right back. Enjoy the techno. Be right back. Okay, contract administration. The engineer should ensure that the construction contract is administered in accordance with its terms. All too often, a contract is administered in a manner that is to some extent contrary to its terms. For example, payment dates may be overlooked, contract extras may proceed without written authorization required by the contract, parties may ignore notice requirements that were stipulated in the contract, the conduct of the parties during construction may bear little resemblance to the conduct that was contemplated when the contract was signed. Conceivably, the issue of equitable estoppel may arise. For example, if contract extras proceed without written authorizations as contractually required, a party may be equitably estopped from denying that it had waived its contractual rights. It is better to avoid complicating the matter. This can best be achieved by closely administering the contract in accordance with its terms. The engineer administrator on a construction project should keep very detailed records, thus the engineer will have evidence of the manner in which the contract was administered and the circumstances of the actual construction. The records should include a daily diary, carefully drafted minutes of meetings with contractors' representatives, owner and engineer, and detailed notes of all developments, which might give rise to claims. During the construction, the engineer might be asked later to recollect events during construction, for example, in connection with subsequent delay and interference claims. Drawings and specifications. One of the most important services provided by the engineer on a construction project is the preparation of conceptual and detailed drawings. The specifications to describe the work, the engineer's description of the work will form the basis of contractors' prices, and the engineer's client will rely upon the plans and specifications as well. During construction, disputes often arise as a result of incomplete or ambiguous specifications. For example, where mechanical hardware, door locks, fasteners, and so on is mentioned in the specifications, although quantity is specified, there may be no reference to a particular product or manufacturer. If the contractor installs hardware of poorer quality than that anticipated by the project owner, and if the construction contract has a stipulated price or lump sum basis, then a dispute may well arise. It is surprising how often an owner and a contractor will begin construction without detailed drawings and specifications. In an attempt to expedite construction, or expedite construction, usually to avoid escalating costs or to take advantage of more favorable weather conditions, such action might reflect the best intentions, but it can obviously lead to disputes about the true meaning and intent of the contract documents. Detailed project drawings and specifications should include all required dimensions, units of measurement, quality materials, and also product designations of parts and equipment. Product standards should include references to recognized testing authorities, such as the Canadian Standards Association, CSA, or the American Society for Testing Materials, ASTM, wherever possible. The importance of detailed specifications was illustrated in the 1979 decision in Trident Construction Limited versus W.L. Wardrop and Associate al. Justice Wilson of the Manitoba Queen's Bench displayed a sympathetic attitude to the contractor where the engineer had failed to specify a proper design. The judge considered whether the likelihood of disaster might have been detected if the contractor had investigated or reworked the engineer's design. In the building trade in Manitoba, not only does the owner rely upon a consulting engineer to prepare competent and reliable structural drawings for the erection of a building in accordance with those drawings, but also the contractors who were called upon to tender for those buildings on the basis of such drawings and specifications must also rely upon the accuracy and competency of these drawings. The normal practice is for the engineers to take months to research and prepare the plans and specifications involved in a project for which they are paid substantial sums, and to give the contractors only a few weeks to prepare and to submit competitive bids for the construction of the building based on such plans and specifications. In this time frame, it is impractical for any building contractor in Winnipeg to check out independently the structural design of buildings involved in the plans and specifications prior to bidding. During the few weeks open to him, he is fully involved in doing takeoffs and getting and collating prices. During that time, he has to go through volumes of specifications and many sheets of plans to establish what materials, machinery, and equipment he has to order, and to compute the labor involved in obtaining and procuring, fabricating, constructing, and equipping such a plant. The task is made much more difficult by the series of late, extensive, and complex addenda that are usually issued up to the very day on which tenders are called. The general contractor must also obtain bids from the various subcontractors, and the subcontractors must in turn obtain quotations from their various suppliers and subcontractors, and the whole must be gathered together to make up the total bid of the general contractor within the bidding time allowed. There, in fact, is no time for anything else except the foregoing under the standard bidding procedures for a large project, and the bidding represented no exception to the general rule. So that means that the onus is on the engineers, I guess. So they sympathized with the contractor because it's such a tight schedule. There's no time to even look over to properly analyze it. They're just trying to frantically make the bids, I guess, and make it all work. So there's no time for that for a large project. Okay, interesting. So the court sided with the contractor in suing the engineer. The tendering process, where contractors submit competing bids. In the project tendering process, the acceptance of any one of these bids constitutes a contract, or the basis for the formation of a contract between the successful contractor and the owner. The selection depends on the particular terms the owner has outlined in its tendering documentation. As the owner's agent, the engineer is usually involved in the preparation of tendering documentation. The information to tenderers package should be tailored to the particular project. It will normally include a general description of the nature of the project, plans and specifications, information with respect to where more detailed data may be obtained, for example, a reference to soil reports, bid deposits or bid bonds that will be required at the time of submitting the tender, and the date, time, and place for submission of tenders. The package also normally includes a statement that the lowest or any tender will not necessarily be accepted by the owner. The tendering issues identified in Chapter 16 should also be carefully considered in preparing the tender package and in administering the award of the contract. The Contract A complexities identified in Chapter 16 complicate the preparation of the tender package, and preventive legal advice is typically advisable. A tender is a contractor's offer to complete construction as described in the bid submission. Some tendering procedures are set up so that the owner's acceptance of the contractor's offer will constitute a contract between the owner and the contractor. It is important to include a form of the construction contract that the owner is prepared to sign as part of the documents delivered to the contractor prior to its bid submission. The engineer should advise the client of the need for preparing a contract form that is appropriately tailored to the project. A drafting process that is best left to a lawyer who can prepare the contract on the basis of the engineer's and the client's instructions. Contractors who submit bids on construction projects on equipment supply contracts will often qualify the basis upon which their bids are submitted. They might, for example, take exception to terms and conditions included in the owner's form of contract. Such qualifications change the basis of the proposed contract. Until the owner is prepared to accept the contractor's revised terms and conditions, the formation of the contract will be delayed. Usually there is a straightforward business negotiation between the owners and the contractor's representatives. The parties try to work out an agreeable basis for the contract so that the work may proceed. Subject, of course, to avoiding breach of Contracts A as referenced in Chapter 16. The engineer might be engaged by the owner to assist in the negotiation process. The engineer should monitor closely the details of the negotiation and should document the final agreement between the parties. A well-drafted contract can then be finalized and signed. Where work proceeds before detailed terms and conditions are finalized, the potential for contract disputes increases. Whenever construction proceeds before contract documents have been finalized, the door is open to unnecessary headaches from contract administration. The contract should be finalized and executed at the earliest possible opportunity. The contract provides the engineer administrator with a defined basis upon which to proceed. Types and forms of construction contracts. Under common law, parties have the right to choose their contract terms and conditions. There is no prescribed format for construction contracts. There are, however, certain types of contractual arrangements in contract formats that are being used in the industry. Some of these formats have been reduced to standard forms that are widely accepted. However, the engineer should adopt a critical approach to the use of standard form construction contracts, or the use of any standard form contract. The parties should closely examine a proposed standard form to determine if it reasonably reflects the agreement they wish to express. Any modifications to the contract should be clearly and appropriately drafted, preferably by a lawyer, and incorporated into the wording of the contract prior to its execution. Some examples of different types of contracts currently in use in the construction industry are listed below. 1. The stipulated price or lump sum contract. This type of contract gives the owner the benefit of knowing the total price that will have to be paid to the contractor for the completion of the construction, subject to additions or deductions to or from the work as the course of construction proceeds. In accordance with the terms of the contract documents, when the stipulated price contract form is used, it is essential that detailed plans and specifications form the basis of the contractor's price. The engineer should carefully define and fully detail the work involved at the outset. The details are provided after the price has been tendered. The contractor may claim that the work is beyond the scope of the contract, as the contractor understood it at the time of bidding. The contractor may claim that additional compensation is warranted. The stipulated price contract may involve a considerable degree of risk for the contractor. For example, extra costs may be incurred if subsurface dewatering or weather problems arise. The contractor should set the initial price accordingly. The stipulated price contract does provide the owner with the advantage of a reasonable approximation to the total cost of the construction, but a word of warning: if the contractor has submitted an unrealistically low price for the work, the contractor may conceivably try to cut costs and look for opportunities to claim extra compensation. Insufficiently detailed specifications may well assist a contractor in such attempts. So what are they saying there? They're saying if the contractor has submitted an unrealistically low price for the work, the contract, so it's basically, let's say that it should cost $1 million to build it, but they're only offering 800 grand. The guy building it will be like, well, I'm only gonna make like 50 grand on this, so let's try to cut corners so I can make 150 grand. They're gonna use lower quality stuff. So if you're gonna screw someone over like that, they're gonna screw you over a little bit too. So that's basically what they're saying. So if you insufficiently detail how they have to do it, like what material exactly they have to use, they might use a cheaper one. So they'd be very so make sure you're sufficiently detailed if you're offering a very low price, as the engineer. Unit price contract. This type of contract is used often for projects where it is difficult to predetermine quantities. For example, in an excavation project, the extent of varying subsurface conditions might not be determinable in advance. Bids are submitted on the basis of price per unit of item. In preparing specifications, the engineer should ensure that the quantity, units on which prices will be based are clearly spelled out and should also list alternatives. In excavation projects, for example, the engineer should request prices for removal of either rock or earth, because earth is obviously much easier than rock to remove. You might need to dynamite the rock, you might need to get a very expensive machine, but dirt, you kind of just get one of those cat shoveler things. Cost. So number 3, the cost plus contract. cost plus percentage, this type of contract provides compensation to the contractor for its costs incurred. As well, it provides a reasonable percentage to cover the contract's overhead and profit. The cost plus approach is often used on large-scale projects where there's not enough time to finalize detailed plans and specifications. To take the time may not be practicable in light of the urgency to proceed with construction. In large-scale projects, there is also the likelihood of changes in the work that the owner may wish to effect from time to time. Note that the cost-plus contract provides no incentive to the contractor to reduce costs. The contractor is being paid a percentage of the total construction costs. The engineer administrator should closely monitor the progress that the work is performed at a reasonable cost. It is advisable for the owner to be expressly entitled to access all of the contractor's project records. This will facilitate the extensive, detailed administration that is usually necessary. So, a different form of that is the cost plus lump sum fee. This contract approach is much like the cost plus percentage arrangement, but the contractor does not receive a percentage of the project costs. Instead, the contractor is paid a fixed amount. This may be the owner's advantage. This may be to the owner's advantage. However, although the contractor receives no incentive to increase the total cost of the contract, there is also no incentive to reduce costs. As with the cost plus percentage arrangement, the engineer administrator should closely monitor the work to ensure that the contractor is not being careless in coordinating and scrutinizing work that is performed by the various trades. A third form of that, the cost plus lump sum fee plus bonus. In this type of arrangement, the contractor is provided with an incentive to reduce costs. For every dollar saved on an agreed estimated total cost, the contractor may receive an additional compensation in the form of an agreed upon percentage of the saving. This approach makes good sense for the owner as long as the agreed estimate is a reasonable one. Usually the owner will expect the engineer to advise the owner on the reasonableness of the contractor's estimate. An inflated estimate would obviously increase the contractor's likelihood of benefiting from the bonus arrangement. Okay, number 4, now we have the guaranteed maximum price plus bonus. Like the cost plus bonus contract, the guaranteed maximum price contract incorporates an incentive to the contractor to effect savings on a cost plus project. The contractor receives a fixed fee as well as an agreed upon percentage of savings. The guaranteed maximum price contract offers the owner a further advantage over a basic cost plus contract. The guaranteed maximum price feature, the amount of the guaranteed maximum price should be determined on the basis of detailed plans and specifications rather than on the basis of a reasonable estimate. Again, the owner usually expects the engineer to advise on the reasonableness of the contractor's maximum price. Number 5, design-build contracts. With this type of contract, it is normally the contractor, rather than the owner, who arranges to obtain the necessary engineering design services. To finalize the design detail. The detailed design is often finalized as the construction work proceeds. The construction may proceed promptly. Detailed plans and specifications for subsequent phases are finalized at a later date. The work often proceeds at a cost plus bonus basis. This appeals to owners who wish to avoid retaining professionals. In design-build contracts, the engineer is usually the agent of the contractor, but the contract normally entitles the owner to retain, at its option, its own engineering representative. The owner's engineer will double-check the sufficiency of the design services provided, and the engineer will also be expected to ensure that construction proceeds in compliance with the agreed-upon plan specifications. Okay, so that was a bit of engineering law. If you enjoyed the video, give it a like and a thumbs up. I'm going to record some more tomorrow probably. And thank you.